And that's
Justice Jackson?
Yes, I'm interested in your conversation with Justice Gorsuch about the sort of original meaning of the direct tax clause, and I'm trying to understand whether it's your position that as an original matter, the direct tax clause was interpreted to include income and all sorts of things, or was it narrow? I had thought originally, as we said in the Hilton case, that it was pretty narrowly focused on capitations and taxes on land. Am I wrong about that?
The Hilton case had 3 seriatim opinions. 2 of them viewed it as a consumption tax regarding conveyance of persons. The third of them, by Justice Iredell, adopted the view that, well, if it's difficult to apportion something, then it should not be subject to apportionment.
What about Justice Patterson's explanation that this was a pretty narrow clause and that it was designed to protect southern states and slavery from federal interference, that was really what was going on here, and therefore, when you're looking at direct taxes, you're talking about, taxes as opposed to indirect, you're talking about certain kinds of things, and that it's not necessarily others, income and that sort of thing.
Well, I think as a matter of original meaning, that's incorrect, but I would note in the context of that opinion, it was dicta. It certainly didn't stand for the position of the court.
Did the court, until McComber, hold that income was direct?
Not with respect so much to income, Your Honor.
I'm sorry, Pollock is what I'm saying, Pollock.
Well, I think the case that addressed this issue prior to Pollock was Springer, which did adopt the narrower interpretation of the direct tax clauses.
So up until Pollock, which was addressed by the 16th Amendment, we had a very narrow conception of direct tax.
For a 20-year period, there was. Subsequent to that, as I said, pretty much all of the court's 16th Amendment cases over the past century have concerned taxes on personal property in the form of investments. So I think the court would really have to upend its jurisprudence if it were to decide at this late date that the direct tax clauses ought to be given some other interpretation.
All right, let me ask you about realization. Going back to Justice Thomas's very first question and what the definition is. I guess I'm trying to understand whether you think Congress has the authority to define what constitutes realization or not. Is that something you are giving to the court through constitutional interpretation, or who gets to decide what the realization line is?
Well, I think as an initial matter, yes. I mean, Congress does get deference on that, but it actually has to try to do that, which is not what it did in this case. I mean, again, the tax here on its face turns on ownership of property on a particular date, and it doesn't take into account.
No, I guess I don't understand your answer. If Congress, could we find that there is realization in this case, that there is realization? Like, who makes the definition of realization? Could the court determine that there's realization here under a definition that we are appreciating?
I mean, the government has never argued that there's realization in this case. The government has simply presented its the other argument that realization is not required. So I think it would be unusual for the court to reach out and decide a question of that import, which in that it's applied since nearly the dawn of the 16th Amendment. So I don't think we're... Even
though the 16th Amendment doesn't have realization in it, you're saying that the implied realization requirement has a definition that you're asking the court to adopt.
We're simply asking the court to say that realization is necessary as that concept has been espoused in the court's decisions over the course of a century.